Should juveniles who commit rape or murder be treated as adults? That's the center stage face-off for tonight. Joining us on tonight's program, Maneka Gandhi, senior police officer, works very closely with Children Reformation, General Secretary of an NGO called Prayas. Dr. Anjana Kumari is the director for the Center for Social Research, and we've got Shaina NC, spokesperson for the BJP. I want to go across first to Maneka Gandhi, because given what happened in the Nirbhaya case of December the 16th, given the anger and outrage that's built up against juveniles who commit such gruesome crimes all across the country, it seems India, sir, is at a level where people out in the street believe that the time has come to de-link age from punishment. You still are amongst the people who believe that juveniles should not be treated as adults when it comes to punishment. Why do you hold this view, given the fact that now even the minister says the time has come to change the law?
It is not my view at all. Let me clarify first of all. That's the view now taken by the Supreme Court of India also. Recently, as you know, following the same case that we are talking about, in the Honorable Supreme Court of India, two massive cases, historic judgments have been passed. Salil Bali case and Mr. Subramanian Swamy case. In both the cases, going into minutest details of this entire issue, the Honorable Supreme Court of India have come to a conclusion that children must be given differential treatment. It is not an issue of juvenile who commits a rape being tried this way or that way. It's the entire issue hinges upon whether the child, less than 18 years of age, should be given differential treatment, which is being given in India, of course, and India being a very progressive country from that point of view. Now the issue is that there is something called juvenile justice system which takes care of judicial process of the child, and there is something called criminal justice system which is for the adults above 18 years of age. Now it is at the age of 18 years that a child acquires adulthood. He gets right to vote, right to marry, right to drive, right to legal action, right to even engage a lawyer.
Sir, but that is the very premise of the argument that is being challenged, Mr. Kant. Given the high levels of exposure now, young kids are maturing much earlier. Is 18 the age at which you become an adult, or is it 16? Is that not coming down with greater exposure to television, India opening up the way that it has? Notions and mindsets are changing, and that is the reason that necessitates the change in the age law, sir.
Now the issue is that if you want the child to be tried as adult, then you have to give the child adulthood at that age. If you want, there are cases, I mean, if you go into the very details, others are talking, I am also talking about it. Let's say in India about 35,000 crimes are committed by children, as against USA where probably it's 12 lakhs, 1/4 of population. Just let me finish this point. And then there, let us say about 3,000 crimes are committed by the children, which are serious crimes, including maybe about 1,000 rapes in a year. Now the issue is that if you want to convert the child into an adult, then you have to really convert completely. The child should have a right to defend also. In that sense, reduce the age of adulthood from 18 years to 16 years. Let the child become an adult. Let the child be tried by an adult.
You're saying change the age of adulthood? But in the current scenario, there is a problem, Shaina NC, because India is a signatory to the United Nations Child Right Convention, which has fixed the age of a juvenile at 18. Now, given the fact that you're part of an international convention, Maneka Gandhi cannot pull through what she's suggesting, even though it's a populist thing to want to do. India, because it's a signatory to this UN convention, cannot do this.
Well, let me put things into perspective, Rahul. First, if a child, so-called child who is 16 to 18, acts like an adult criminal and rapes, molests, murders, isn't it a heinous crime which needs to be debated upon? Isn't it a crime where he needs to be given a punishment which is so befitting that it turns into a deterrent for all the others who are sitting on the fence? Now, I want to just say 2-3 points. When it comes to serious issues like murder, rape, etc., irrespective of whether that child or that juvenile or that adult, as you may wish to call, whichever term you choose to use, is between the bracket of 16 to 18, there are thousands who are sitting out and waiting and watching in the wings if they can do similar crimes and get away with it because of the loopholes in the system or the loopholes in the law. Now, Maneka Gandhi's thought process is absolutely to be appreciated by one and all, because she is saying that if a 16 to 18-year-old does something which is so perverted, the punishment needs to be the same. So it acts as a fear of law for all the others sitting out. Whether this needs to be amended through the Juvenile Justice Act, or whether it needs to be understood that the age group which is 16 to 18 that is convicted for murder, rape, etc., needs to be viewed as separately as...
No, I want to contest what Amod Kant is saying.
That is the point of
question.
question.
I want to contest what Amod Kant is saying, because we have a scenario now where there is a latest report which suggests that there is a diktat from the Lashkar-e-Taiba commanders in Pakistan telling militants that if you get caught, tell the cops, tell the army you are below the age of 18. Now this is, and details of this tactic were given by a terrorist by the name of Muhammad Naved Jat, Abu Hanzala, who was subjected to age determination test as he claimed to interrogators that he was 17. Now you've got the Lashkar using this as a tactic. And there's a report here which says that 50% of the crimes are committed by people who are about 16 years of age, who know the provisions of the Juvenile Justice Act. So while I know that you're trying to protect the best interests of children,
they can get away.
Here is a situation where juveniles or supposed juveniles know about the Juvenile Justice Act and they want to misuse, Mr. Kant, those provisions. Why should we allow them to do so?
Can I respond to it?
Yes, Mr. Kant, you must.
See, first of all, let me okay, now my point is very clear, that if the child is being lured into insurgency, if the child is being lured into drugs, if the child is being abused and misused by the adults, does it mean that you always punish the child, not the adult? If Lashkar-e-Taiba, anybody else is asking children to come and claim childhood, for instance, it is not the child's fault. I mean, the child can't be punished for that. That's the point. And secondly, let me qualify.
By that logic, no child should be punished.
How did you say that 50% of...
That's a figure Maneka Gandhi is given out.
Aware? No. Oh, ma'am, Maneka Gandhi, what she says, I mean, this morning I spoke to her, I tried to tell her, and she says that our point of view being... Listen, the point is that in India, the total number of crimes committed by the children is only 1% of total crimes, number one. And the heinous crimes or the serious crimes committed by the children in the whole of country, 1.21 billion population, is just about 2 to 3,000, including about 1,000 cases of rape.
So are you suggesting, Mr. Kant, that those 2 or 3,000 cases go unpunished? That
so
juveniles who know the provisions of the Juvenile Justice Act commit these heinous crimes and get away after 3 years?
Look at the statistics on the repeat offenders.
Look at the sort of barbarity that these juveniles are getting away with. Why should they be allowed to do so, Mr. Kant?
If I can explain the law, please bear with me for a moment. See, the law for the first offenders, you must have heard about Probation of Offenders Act. Under the Probation of Offenders Act and section 360-61 of CRPC, a young offender up to 21 years of age, number one, is let off. A young offender is not being given death sentence or life imprisonment. And under the law already, in fact, the law is more liberal to the young offenders under criminal justice system than under juvenile justice system, because juvenile justice system, a child goes into some kind of...
But that's the point. I think you're missing the point, Mr. Kant.
No.
You are citing the current law. We are explaining the problems with the current law and saying that you should delink age from punishment. Forget whether he's 21 or 18. Look at the severity of the crime. If there's rape, if there's murder, act against him. I'm coming back to you, Ranjana Kumari. Amod Kant cites again and again the provisions of the current law to argue that these provisions cannot be changed. Do you think it's time to junk the Juvenile Justice Act in the way that it exists at this time and to build a new law which says punish people for their crime as opposed to looking at their age, make age irrelevant to the crime and to the punishment?
I mean, the age is immaterial
Rahul,
according to you.
We are
a child of 14 can be given death sentence. A child of 14 can be given death sentence. That is what you want. You want a child of 15 to be sentenced to life.
Well, if he's committed murder and if he's committed it knowing that this is murder, then yes, he must be punished. I want to listen to Ranjana Kumari.
Committed means you sentence the child. No, you sentence the child. You don't try.
I think let Amodji have patience to listen to what I have to say. I think what I'm going to, I think we are discussing two things. One is the children and their protection and protection of child rights. That is, of course, the Juvenile Justice Act ensures that. But at the same time, what we are discussing is fixing the criminal responsibility. Now globally it is understood that between 10 and 18, children are committing serious crime.
Absolutely.
And as Amod Kant himself says that they are committing murders and rape, and especially the whole debate started after Nirbhaya. So now fixing the criminal responsibility, whether it is in Australia, whether it is in England, and also in America, the nature of crime is 10 years. It's 10 years of age, because you can't say child. I mean, extending child till 18 is really not acceptable kind of a situation, because there is a teenage factor there, and there are between 10 and 18 there is an age that changes, and also body that changes, and mind changes. So I think it's important to understand that criminal responsibility should be fixed 10 onwards. If it is heinous crime, looking at the nature of crime, severity of crime, you have to fix that responsibility, and accordingly the punishment will follow. Because you cannot look at the Nirbhaya case and look at the 17-year-old who did the maximum crime in terms of brutality, and look at the way, the kind of punishment that he was meted out. Now this has to be resolved. I think at that point of time we already suggested that there is one provision within the Juvenile Justice Act which says graded punishment. That means the kind of crime the child has done, and also referral, that you can refer it to the normal criminal system if
you hit the nail on the head, and that is what I want to tell Amod Kant. You're absolutely right, ma'am, and that's the point that I want to argue with Amod Kant about, because why can't we follow, Mr. Kant, the provisions of the British law and the law in the United States? Let me explain that for a moment to our viewers. In England, juvenile courts do not, as a rule, deal with homicide and are free to send cases of rape to the Crown's Court. Similarly, in the United States, most states treat murder as an adult crime, and juvenile courts transfer cases of severe offences committed by juveniles to regular courts. Now you say, here's a juvenile who's accused of murder or rape. Let the adult criminal system deal with that. This is not a juvenile case. Mr. Kant, why can't we have a similar provision in India?
Can I just two very small points?
Yes, Mr. Kant.
Heinous crimes will also be dealt with accordingly.
As a response to Ranjana's point.
Yes.
As a response to Ranjana's point in the first place, let me clarify that Indian Penal Code has got three kinds of criminal responsibility. Up to 7 years of age, child commits no crime. 7 to 12 years of age, according to the mental development of child, he commits a crime. And beyond 12 years of age, up to 18 years of age, the child's culpability is very much fixed. Don't tell that the child's culpability is not fixed. The criminal responsibility starts coming on the child right after 7 years of age.
No, Mr. Kant, but why can't we follow the model applicable in the United States and in the United Kingdom? That if you commit a heinous crime, your case will be dealt by the adult criminal system, not by the juvenile criminal system. Just link it with the nature of crime rather than age.
Think about. I would suggest Amodji that this is time to think about change, because this is going to become big issue. It is already a big issue.
We are for the change. I am not saying.
A lot of people are not letting go the 18-year-old, 16, 17, 18 who are committing very, very serious, severe crime. So I think they need to be referred by Juvenile Justice court to the normal court, and also that they should be tried according to the law of the land, which is for anybody.
Ranjana,
yes.
We are not against changes in law. In fact, we are also suggesting changes in law. The point we are trying to make, that a growing person, when there is already a law for the adults, young adults, why are you not giving a differential treatment? I am not saying keep him in custody for 5 years, 6 years. In fact, I am on record suggesting it. That right now a child can be kept in custody for 3 years, make it 6 years. We have no problem at all. The issue is that a person, an adolescent or a young boy, young girl, if they commit a serious crime, they should not be subjected. They should not be subjected to normal criminal justice system.
Why not?
They should be thrown to jail.
No, but why not, Mr. Kant? Just 1 second. I'm asking you a straight, simple question, Mr. Kant. If that person is old enough to know that he is committing murder or rape and does so knowingly, and this can be established in a court of law, why should he not pay for it, Mr. Amod Kant?
See, the point is, the point I am trying to make, that are you completely negating Are you completely rejecting the reformative system of justice? Are you completely saying that no person should be given a chance to reform?
Not
That's
after
what you're
committing
trying to
murder
say.
or rape. That can be for theft.
And
that can be
you
for
are
a petty
comparing-
offense,
no,
Mr.
you are
Ahmad Khan.
comparing.
It cannot be for a heinous crime. That's the proposition I'm challenging.
There are open jails.
One point.
See, in this country there are open
I
jails.
think
Please don't
Rahul,
forget.
I think-
In this country there are paroles.
For whom
Rahul, let me-
reform
The adult system also have
No,
reformation.
one
there.
second. I request both my guests not to speak
Let
up
me make
simultaneously
a-
and for
let me
and
make
please,
another
Ranjana Kumari,
point.
wait for my cue. If everyone
No, let's
speaks at the
talk one
same
by one.
time,
Let's talk one
then
by
our
one.
viewers cannot make sense. We don't want to be like the other channels where everyone speaks at the same time. That's cacophony. That's not news. That makes absolutely no sense
Okay,
for our
now,
viewers.
is-
There's a point that Amod Kant
is
makes,
this
and I
my
want
turn?
Ranjana Kumari to respond to that. That if you put a young adolescent behind bars where he's in the midst of hardened criminals, you take away any possibility of reformation.
Please.
That's the argument that he's offering, therefore suggesting that adolescents be treated differently from adults. Dr. Kumari.
That's the point. That's the
Well,
point.
I think
Thank
the
you.
possibility of getting exploited, getting treated badly by the other criminals, and also that is why child rights, that is why Juvenile Justice Act, that is why all those provisions have been created globally. It's not only in India. Globally, it is an accepted fact that if you put a child with adult criminals, certainly they'll be exploited and there'll be a problem. But I'm saying something else. I'm saying that, look, if the 18 years, 17, 17, I mean after 12 years, if the criminal act is as heinous and as serious and severe as any adult would do it, then certainly the consequences will have to be as serious. You cannot then let it go. You cannot say that the 18-year, he or she is not 18-year-old, below 18, let them be in 3 years for reform, and then you can't really protect repeat offense. Repeat offenders then are not able, and then there is no monitoring system. After you have reformed them, so-called 3 years of reform, which I think is worse than in reforming, because you can go and see the kind of condition these youngsters live who have committed crime. So, and also the crime, the punishment cannot be for, theft to murder. It cannot be the same punishment. You cannot, in the name of juvenile or young adult, you cannot say that somebody who is just pickpocketed or just in small robbery.
You make two
small
important
theft
points.
And also a murder.
I want to
and rape.
cite. I want
It
to
cannot
cite
be
what
the same
happened in
thing.
Canada. Shaina and you must listen to this. In Canada, they had a similar debate to the one that we're having in India, and they reduced the age for juveniles from 18 to 12. Studies reveal that before the act, which is called the Responsible Act, was passed, 9% juveniles committed crimes after rehabilitation. 9% juveniles committed crimes again after rehabilitation. Now, 82% of them commit crimes after they were tried as adults and released. That's 73% more than before. So the argument that people like Amod Kant can make is, if you were to, in popular bloodlust or because the street demands it, makes this change, you could actually end up ensuring that these adolescents who've committed crimes actually end up as more hardened criminals than they do under the current system. That's the counter charge. Shaina Ince.
But
Can I make a
But
point now?
Rahul,
Can I
Canada is
respond to
not
you?
India. We've listened. Please now give somebody
make a
else a
small point
chance,
here?
because I've
Mr. Kant, I'm
patiently
coming
listened.
back to
Can
you.
I
Let
make my
Shaina
point
speak.
and then you can rebut?
Just
I
one
have
point, a
patiently
small point.
listened.
Can I
All
make a
I'm
small
saying is
point?
that Canada
See,
is
you are
not
comparing-
India.
Mr. Kant, just
and
wait
the
for a
fact
moment. Yeah,
that you
Shaina.
brought the Canada is not India, and if you bring the age limit down to 12, we are not talking about 12. We are talking about 16 to 18, and we are talking about hardened criminals who are perpetrators of crime much worse than some senior
No, but
adult
China,
criminals.
what happens
So
in
I
this
am only
instance?
saying 2
You are
points.
saying
One
16.
second.
Hear me.
What about
you are
repeat?
saying 16 in this instance because the person happened to be more than 16. What if he's 15 tomorrow? Will then there be a demand on the street that the age be reduced to 15? Why does this stop? Why 15? Why not 14? Now, these are important questions also that need to be discussed and debated, China.
You just cited an
Can I
example
make a
of
small
Canada
point
where they
now? I
dropped
think
it
there is
from
enough-
18 to
enough
12.
discussion on
We
the
are
point.
talking about 18 to 16. And the point is, please have the patience to hear and listen, sir. We've all listened to you and at length. I have only 2 points to make. that if you constantly talking about a reformist approach, and that too for the perpetrators of crime, why aren't you thinking about society at large and the impact it would have on all the juveniles who are sitting outside? If you want to have fear of law, it has to begin by ensuring that the guilty are punished.
Okay.
And if they're punished
that's an
severely,
important
it acts
argument
as a
China
deterrent
NC
for
makes,
society.
that there is
So this
deterrence.
an important
The
point.
moment
And what about repeat
adolescents
offenders
find
as well,
out
who
that you
get away
can be
scot-free?
hanged, you can be convicted for life, there is a message that goes out that this is something we better stay away from, Mr. Amod Kant. And I want to take you on also on your argument that the juvenile system reforms young adults, because the critics will say that the reformation houses are in such a bad state that people come out as hardened criminals. There's no reformation that happens over there. In fact, you learn how to become a bigger criminal, sir.
Yes.
See,
and nobody
now
follows
that
them
you are-
also, Rahul. Nobody
you are-
tracks the development after that.
Okay, let Amod Kant speak.
Two small points I want to make out of this session. Number one, you said correctly that India is not Canada. I say in the same breath that India is not USA. I have given this comparison. 11.5 lakh cases by juveniles in USA in 2011, 33,000, only 33,000 in this country. So it's not comparable, number one. Secondly, are you disposing of the case while the child is alleged to have committed a crime? Let's say a child of 14, 15 or 16 or 17. There is an allegation by somebody that the child has committed a serious crime. Do you mean to say that you will throw the child in an ordinary court without giving him liberty to defend himself or engage a lawyer, because he can't engage a lawyer, he doesn't have right to protect himself, he is not an adult at all.
No, why
And
not?
then you
Allow
put
him
in
to
that situation
allow him to
in the
engage a
first
lawyer.
place.
Mr.
In the
Kant,
first
why
place.
should that
Who is
right be
going to
taken away
defend?
from him?
No. How can, no, you are taking away, you are forgetting that below 18 he can't do anything, he can't even sign
No,
the
so let him, if he is, no,
below the age
why,
of 18
I'm sorry,
years.
why does it
No,
have to be
cannot
an
be.
either or, Mr. Amod Kant? Why
Rahul,
can't it be such
can
that
I-
if
No,
if your case is going from a
Who will-
juvenile
who
court
will-
to an
who is
adult
going
court,
to defend?
you will have all the
No,
privilege
answer
of
me-
an
answer me
adult
question.
who's an accused,
No,
Mr.
you are
Kant.
not listening to me. I'm sorry, it's becoming one-sided. You are not permitting
We are
me.
listening to
You
you.
are not permitting me because, no, you are not. Listen to me now. I am saying that you have to see, first of all, the moment go to an actual situation. You know, I have been a policeman, 34 years. I understand what the policing is all about, how the crime is being dealt with. There is an allegation. First of all, why do you presume that an allegation made to police is going to be true? It is may not be true also. There are hundreds and thousands of cases where innocent people are being
Well-
charged. There is an allegation, the first thing you do, hold on please, just 1 minute, just 1 minute. The first thing
The
you are
law
going
is
to
not
do,
based
that you
on
arrest the child,
aberrations.
like an,
Law
let
is
me,
not-
let me
Mr.
finish,
Kant, you
let me
know
finish,
that
ma'am.
law is not
Let
based
me
on
finish.
aberrations.
Let me finish, Ranjana, let me finish. Let me
Okay.
finish. One sentence you can
Okay.
grant me.
Okay.
Just let me finish. The point I am trying to make, there is an allegation that there is a case, there is a particular case, murder or whatever case is there, any case. It's a serious crime, categorized serious. And there you want to punish the child. Let us say there is an allegation, the first thing you do, the police will apprehend or arrest the person. And the system, the entire system changes in the sense that the child is arrested or apprehended and then sent to an ordinary jail, sent
No.
to ordinary police station lockup. So your entire case, please finish, let me, one sentence.
But
please
Mr.
give
Kant,
me.
why is it an
See, the
either
point
or?
is that the
Why
entire-
can't he
you are
stay
not
in a
listening to me.
juvenile
You are not
home
listening-
till the
No,
time
now
he gets
can I
convicted?
say
It's not
something
black and
now?
white.
I
Why
want
can't
to
he
just
find
say
a
one
middle ground?
sentence.
Why can't he
No
stay in a
problem,
juvenile
no
home
problem.
till the time he gets convicted? If he gets convicted, he pays for his crime.
There is no
And he
doubt.
can stay in a
point
juvenile
is,
there is no
home
doubt
till the
that
time he attains
there
the
is
age
no
of 18.
doubt.
After he attains
That's
the age
what
of
I'm
18,
saying.
he
That's
must,
what I'm saying,
he
that let
must
him
then
continue
serve the rest
juvenile
of his,
Let him
then he must
I'm
serve the
also
rest of his
saying.
prison,
By which
punishment
time
in
he
prison.
will
Our logic
have-
is-
Let me come in for a minute.
I'm out
We
of
are also
time.
saying,
Let me come in
the
for a
child
minute.
remain in juvenile home.
No, let me come in for a minute. I think the discussion is about hardened criminals who are
Okay.
below 18 and who are really committing serious crime. You have to try them normally, because we are very concerned about children, and we are very concerned about police really catching any child and making the child accept that the child has committed the crime. This is about police, and we all know about that, and we know that you cannot base a law on aberration. I think there is need for a minor change, just one amendment to Criminal Justice Act, the Juvenile Justice Act, that you have to treat any 18 between 12 and 18 or 10 and 18, I think if it is a nature of crime will have to be considered.
Absolutely. I think that's where we end this debate tonight. A middle ground must be found. This debate cannot be viewed from an extremity. You look at the severity of the crime. You let the juvenile stay in a juvenile home till the time he's convicted. Let him stay in a juvenile home till the age of 18, but he must serve out the rest of his punishment and not be allowed to get away scot-free after 3 years, especially if he's committed rape or murder or any other heinous crime. I think we've been able to establish some agreement on this principle. Let it not be argued on the extreme, but we must find a middle ground, and in that what Maneka Gandhi says deserves to be supported. Shaina NC, Ranjana Kumari and Amod Khan for joining me on the center stage face-off tonight. Thank you very much.